Good morning. Good morning. Happy Saturday. My name is Latavia. I am your host of Legacy Conversations, as well as the owner of Legal Solutions, a law firm where we focus on helping you build and protect your legacy. And that is done through entrepreneurship and helping providing protection for entrepreneurs as well as individuals. Just helping you to put documents and plans in place to protect you, your assets, and your family, overall, your legacy. And so, if this is your first time joining, welcome. Once again, my name is Latavia. This is the Legacy Conversations session. This is the September edition of Legacy Conversations. This series was started as a way to, as it's in the title, to just get the conversation started or keep it going, to inform, educate, and also empower people to talk about it. So one, I want to make sure you know what estate planning is, what is legacy, how do you define your legacy, and then making sure that you have a right to create a plan and put a plan in place so that you can protect it. So as you are establishing it. So over the course of this series, we've been going about a year now, each month focusing on a different topic, but the overall goal or focus is under that umbrella of planning, legacy planning. And so in previous sessions, we've talked about just kind of what is estate planning overall, focused on trust, what those are, how to set them up, some of the tax implications, what are the components of a will. I've had guests come in and talk about some of the different areas that overlap or that you need to be aware of with respect to estate planning, such as financial advisors or estate CPAs. And I like to break legacy planning into two components. There's those in documents. There's documents that apply while we are alive. I like to call those the life documents. And then there's those that are our legacy documents, the ones that go into a place or have most of their impact once we have passed away. And so this month, I want to focus on the life documents. Like I've touched on these before. And by the way, if you've missed previous ones, all of the previous sessions have been recorded and are available on the LA Legal Solutions YouTube channel. So you can, including this one, you can go there and watch it. If you missed the live or you want to be able to, you missed something you want to rewatch, or you want to share it with someone, because that's one way to get the conversation started. If you're not necessarily sure how to start it or maybe not comfortable broaching the subject with someone, one way to do it is, hey, here, let me send you this link. Listen to this and tell me what you think. That's another way to do it. So like I said, this month or today, we're going to focus on life documents. And so I consider those to be your power of attorney and advanced medical directive. Both of those require you to have capacity to be of sound mind, to be at least 18 years old. And that's in most states. You need to be mentally competent. So if you think about, hey, are you competent enough to enter into a contract or to sign a contract? That same capacity is required for you to be able to give someone or grant someone power of attorney or to execute an advanced medical directive. So I'll start with the power of attorney. So as I mentioned, you do have to have capacity, but that power of attorney does or covers, and generally it's for financial reasons. You may have heard it if you've purchased a home or purchased any type of real estate. Sometimes they'll have you execute a limited power of attorney where if maybe you yourself are not available due to signing or you want someone to do it on your behalf, they may have you execute a limited power of attorney where you are giving someone power or the authority to stand in your place or sign on your behalf for the purpose of this specific transaction. So that's where it would be limited, where, hey, this is specifically for this date or for the duration of this matter, if it's kind of a joint venture type of situation. So that's limited, where, hey, Latavia am giving person B the power, the authority to enter into agreements to sign things on my behalf and it will have the same effect or impact as though I had signed it myself. And so it's a very big, it's a strong power. So I always encourage people, you don't want to enter into that lightly. You don't want to assign someone as your power of attorney lightly, making sure it's someone that you trust. So like I said, that is the limited nature, but generally what most of what I'm covering today is about a general, or some may have heard it called durable, but really it's a general or full power of attorney or financial power of attorney, where you are given that person that you are designating as your agent or attorney, in fact, authorized agent. It's called a little titled a little differently in various states, but essentially your power of attorney or your agent. You are giving them the authority to sign documents on your behalf, to enter into agreements, to open bank accounts, to open to initiate some types of litigation on your behalf, to enter into business decisions or agreements, on your behalf. And so when you're, like I said, we talked about the limited, a general, it's, hey, I'm just giving you broad financial legal authority to act on my behalf. Then there's the durable one. That's what I think most people think of when they hear about a power of attorney. That means that even in the event that I'm incapacitated, or essentially anything that happens to me while I'm living, this power of attorney is in place. And so that's what most people enter to. There's another type, which is called a springing power of attorney. And that's where I designate, let's say I'm going to use my sister. I designate my sister to be my power of attorney. I'm giving her, broad authority to act on my behalf in various situations, but I kind of put conditions on it that it goes into effect upon the happening of a specific event. So it's not, hey, I'm signing it today. It doesn't go into effect today. Let's say I put the condition on it, hey, uh, if I end up having to be in the hospital and incapacitated for more than 2 days, this power of attorney goes into effect. And then you put conditions in terms of like who has to be the determinant, who makes that decision or that call that I am indeed incapacitated. So that's called a springing one. And sometimes that's beneficial, but I would say the pros of it is, hey, you're putting conditions and kind of limitations on when and how long that power of attorney is effective, and not giving someone kind of carte blanche access to you and your financials. The con of it sometimes is, depending on how specific you say those requirements, those conditions are of who can make that determination when it actually becomes effective. Sometimes that could cause delay. If it's, let's say you put in there, I've seen some where they say you need to have two physicians or two independent physicians make that determination. Depending on where you are, what the circumstances are, that might take a longer time than you may want if someone needs to make a decision quickly. Like I said, so those are the types, but it's broad authority. So in most states, they have created kind of a statutory form or a standard form that each state has kind of put into law. Hey, this is what a power of attorney is. These are the types that we'll recognize. These are the conditions under which we will recognize it or consider it to be valid. And they essentially tell you what language needs to be in there, how it needs to be written, what it format, all those particulars. So it's not something that you necessarily you feel like you have to start from scratch. There is template language available through the state. But you want to make sure, for all of my DIYers out there, or those who like to consult ChatGPT or some other type of AI tool or software, make sure you understand what it says and that it applies to your state and your situation, because you don't want to get a template for a limited power of attorney and you're trying to use it as a general one and you want it to go into effect right away and to be there indefinite, and it doesn't have the language necessary to cover that. You end up using one that's for a limited power of attorney, but you intended for it to be a durable power of attorney. So that's like I said, that's one of the reasons that I want to have these conversations, because as much as I would love for everyone to consult with and or hire an attorney to draft these documents for them or to review them for them, I understand that that's just not the reality. It's not affordable for everyone, and there's some who you don't mind taking the time to read, look things up on your own, or you just want to do it yourself. So I get that. So these are, like I said, this is also to give some tips for those of you who decide to go about it on your own. Make sure you understand what it's saying and that it's going to accomplish what you want it to accomplish. Okay. So with that, you can either say, hey, I want to give kind of carte blanche. You have access to all of the basically any authority the state allows you to have as my power of attorney. I want to give you that power and I want it to go into effect as soon as I sign it, or I want it to go into effect, at a specific date or based on specific circumstances. You get to choose that. Now, if you're someone that says, I do want to give someone power of attorney, but I don't necessarily want to give them access to everything, you can, some templates, like specifically in Maryland, they have it where it's broken down into categories. So it's real estate. Okay, just a moment. Um, they're broken down into categories. So it could be, I'm giving you full access to make decisions for real estate transactions or business operations, uh, legal things, or you could say, hey, if you someone who owns a business, you want to create a power of attorney or give someone power of attorney, but you only want them to have access to your personal affairs. You have someone else that you want to handle things for your business or from the business standpoint. You can have it limited to where you say, I am not giving this person power of attorney to make decisions on my behalf with respect to my business or any business decisions. Or and vice versa. So you could have it where you create a power of attorney and it's specific to your personal endeavors or personal affairs or or all over. So like I said, that's just an example of how you can adjust it. You can also go in and write additional instructions or limitations or conditions that you want to put in there about what authority or how much power you're giving your agent. And so I'm going to back up a bit because, like I said, you need to have capacity to be able to create it. The other thing is you need to actually designate the person that you want. You need to list who it is that you want to be your power of attorney. So you can either specify, I want one person, and say, hey, like I said, if I want my sister to be my power of attorney. So I need to make sure I write out her full name and contact information for her. So that way the financial institution or whatever entity that is receiving this power of attorney, they know who it is and how to contact them. So that way, when they bring documentation to verify who they are, identification to verify their identity, then they can match that up. So you can list a primary agent. You can do a secondary agent. So you could say, hey, in my case, I want my sister to be my power of attorney. But if something happens to her, she's unwilling to be my power of attorney, I am going to list my other sister as the secondary or successor agent. And so you could list up to three, depending on, your people, your situation. So you can list people as kind of like, this is the primary, this is the person, this is second, this is third. Um, or some people decide they have two, maybe even three people that they want to be their power of attorney. And so you say, I want to have co-agents. I list two people that I want to be my power of attorney. And even in that, you could say, I want two, and they both have to be in agreement or they both have to sign off on decisions. Or you could say, I'm listing both, but either or can sign. My caveat or disclaimer when people are talking about listing multiple people as an agent to serve at the same time is to think about who are these people? Are they ones who generally get along and work well together? If they're not, you might want to rethink that. And even if they do, make sure you think through that and have conversations with them so they're clear on what your desires are overall, and then that they're understanding that they're going to need to work together for your benefit. Because unfortunately, if you have two people who don't see eye to eye or just aren't able to agree, it could essentially work against you, because if you have a power of attorney, but they're not in alignment, they're not able to actually make decisions, then things aren't getting done and it's just kind of stuck. So that's something else to think about. So like I said, you have to have capacity, be over 18, You need to designate or specify who it is that you want to be your agent or successor agent or co-agent. Identify the powers that you want the person to have, like whether it's broad or are you going to limit it. And then when you want it to go into effect, it needs to be, if I haven't said this already, it does need to be written. And you need to be doing this on your own, of your own accord. It shouldn't be something you're doing under duress or out of fear. And then once everything is written, you have it all out there, what your wishes are, what your desires, when you want it to go into effect. For it to actually be effective in most states, you yourself need to sign it. And then you need to have at least two witnesses who are present at the time that you're signing, saying that they're witnessing you signing it. And then you also need to have it notarized by a licensed notary or authorized notary for it to be effective. Because if you sign it and let's say you have it witnessed, but you don't have it notarized, no one's going to accept it. And in some states, like I know this is the case for North Carolina, you also need to record it. And so that's the other reason I was saying you want to make sure you're consulting with an attorney or doing your own research to make sure that one, if you are using like some template language, that it is language that complies with the laws and requirements of your state. Because if you do a power of attorney that is, it's essentially has language for Maryland, and then you want it to be used or applied in Virginia, although they're very close, Maryland and Virginia are two completely different states with different requirements. Same for DC. So you want to make sure that it is something that it can and will be recognized by other states. So for it to be recognized by other states, it needs to be valid in the state that you're living in. So it's not to say that if I have a power of attorney and I'm in Maryland and I executed it in Maryland, it's valid here. And then I end up, I don't know, in Arizona and I need the person who has power of attorney to be able to make decisions for me there. It can still be applicable, but you need to make sure it was valid. But if you had one that was created and it wasn't deemed valid when you were created it, then it's no good. So that's the power of attorney. Like I said, you need to be of sound mind, have capacity, be mentally competent, be 18 years old. It needs to be voluntary. It needs to be written down, and then you need to sign. It needs to be witnessed by two people, and it needs to be notarized. So you also want to make sure that with respect to your state, if signing it, signing witnesses and notary is sufficient, or if it is required to be recorded. So that is the power of attorney. And for any of you who have heard or think that the power of attorney, if you were the power of attorney while the person was alive, then you still are the power of attorney after they die and you can still do things, that is false. The power of attorney applies while the person is alive. So unless that person had a will or a trust in place where they designated the same person to be their power of attorney as well as the personal representative or executor of their will, when that person passes away, your authority to act on their behalf, it dies with them. It ends when they die. So power of attorney is good for while the person is alive. It does not, even if it's durable does not mean that it is effective once the person has passed away. So that is the power of attorney. I am going to switch now. We're going to start talking about the advanced medical directive. So the advanced medical directive or healthcare directive, depending on where you live, it might be called one of those two things. But the overall purpose of it, it is to serve as essentially you designating someone to be able to make decisions for you or on your behalf in the event that you are unable to, specifically or generally with respect to you're incapacitated. So this also is a form or a document that most states have created, a statutory form where it has that standard language. Okay, just a moment. Okay, I'm back. I had to tend to my little one. Because that's a part of my life. Okay, so we were talking about advanced medical directives. And so, like I said, it covers you while you're alive at healthcare decisions, medical decisions, and most states have created statutory language that covers it in terms of what format, what language they will accept. Often at this point as well, a lot of physicians or in hospitals have versions of this. Oftentimes, especially if you are going in for some type of a procedure, they will ask, sometimes even in, I've noticed in general intake forms, they'll ask that question, do you have a will? Do you have an advanced medical directive? Like, do you have any of these documents already in place? If so, do you want to upload it? If not, do you want to talk to someone about that? So sometimes you can do an advanced medical directive with your physician or your primary care doctor. It's and one good thing about this kind of the advance in technology is most doctors' offices, they're a part of, like a larger medical group. Like I know in Maryland, there's the University of Maryland system. In North Carolina, there was, UNC system or Duke Hospital. They have kind of I guess, a network of doctors or offices that work in there, and they have their electronic medical records. And so if you put it in there, you don't necessarily have to physically take it or hand it to a doctor the way you would have done years ago. You can upload it and then they have access to it. So that's just like I said, in terms of once you have it, how it can, the impact of it. But what it is at the heart of it is, it's like I said, you are designating a person or people to be your agent, to be your healthcare agent, or your healthcare power of attorney is, or proxy is also how it's referred to some places. And so with that, you're appointing someone to act in your place. So similar to with the power of attorney, if for some reason I'm unable to make these decisions for myself, or I need some assistance making these decisions, I am designating a person to act on my behalf, which also gives the medical providers, or in the case of the power of attorney, the financial institutions, it's giving them permission to speak to that person on your behalf, to speak to them about you, about your medical care. And so with that, once again, you have to be 18 years old, at least 18 years old, have capacity. So that same capacity that's required to execute a power of attorney is required to do an advanced medical directive. And I'm emphasizing this capacity piece is because unfortunately, there are situations, sometimes things happen unexpectedly. And I've had people reach out to me or that I've worked with that even in my own family, something happens, there's a medical crisis, and then the person is incapacitated, either temporarily or long term. And they're saying, hey, I need to be able to make decisions. I need the doctor to talk to me. The doctor won't do this, or we want to be able to get this type of treatment or access to this, but I'm not able to, or I need to be able to get the money. They have money in their account, but I can't access it and they won't give it to me. And unfortunately, if that person is incapacitated, they are not able to then sign a document giving you power of attorney or making you their healthcare agent so that these respective entities will talk to you and give you the information or access to the things that you need. And so that's why I said I'm emphasizing that capacity piece, because I want us, and I'm saying us because I'm a part of this too, to create these documents while we have capacity, while we are very much in clear mind and know what we want. We're able to make these decisions for ourselves. It also limits the risk of someone having undue influence on you to make these decisions, to try to get you to sign something or you to feel like you're coerced or you're signing it under duress because it's a last minute type of situation. So that was my little soapbox tangent. But like I said, you need to be at least 18 years old, have capacity. It needs to be voluntary. It needs to be your decision. I am choosing to designate my sister to be my healthcare agent. Or in my case, I'm going to say one of my friends who is a nurse, who is a medical professional. I am designating her to be my healthcare agent. It needs to be in writing. You need to sign it, and it needs to be witnessed by two people. Some states require a notary as an alternative to witnesses. But once again, that's something you need to check with your state to make sure you're clear on. Consult with a legal professional. Uh, I can tell you for Maryland, DC, and North Carolina, you need to sign it and have two witnesses. The notary is not required, but some people do it just for good measure. But like I said, so that's what's required for it to be valid overall. With respect to the notary and the witnesses piece, you want to make sure you check with your state. Another caveat to or thing to keep in mind with respect to the witnesses, in the advanced medical directive, you can't have both people who sign as people who are also ones who stand to inherit, like who are your heirs. So I had this come up with a client where someone, it was a woman had an advanced medical record created, and both of her grandchildren ended up signing as witnesses just because, circumstances they weren't necessarily able to get two other people. And they both signed, which then made the advanced medical directive invalid. And it essentially as though she didn't create one, even though when she was of sound mind, she signed it, she made that designation about what she wanted to have happen, how she wanted decisions to be made. But unfortunately, it was deemed to be invalid because both of the witnesses were her heirs. So what I tend to do with any document I am facilitating the signing of, I try to have it where you have two completely uninterested witnesses sign for that very reason. Like if it's, if and sometimes even if it's a document that I created, if we're not able to get two uninterested witnesses, sometimes I will sign myself as a witness, or I will end up doing the notary just to make sure that we're not having someone who stands to inherit sign off as well. And part of the reason of that is once going back to that, making sure it's voluntary. In the event that something happens and someone wants to challenge, there's a negative impact, and another family member comes in wanting to challenge a decision that was made or challenge the person being appointed as that agent. uh, it helps to make sure that it was uninterested people who witnessed it to say, hey, yes, I am attesting that this person, in front of me, they created this document. They are doing it voluntarily of their own will. They're not being coerced. There's no undue influence. And I'm witnessing this. I'm signing as a witness that this is what happened. And this is their desire, that they want to designate this person to be their agent. So that's, like I said, for it to be valid, that's what you need to do. Now, what that healthcare power of attorney or the advanced medical directive, what it covers, like I said, is you can do it in multiple parts. There's where you're just designating the agent. I am specifying I want person A to be my agent. And the same as with the power of attorney, you can designate you can do it, hey, I want a primary, I want someone to be the secondary or third, tertiary, third, if something happens to them or they're unable to, to serve as my agent. And what you can also say, I want to have co-agents. I give that same disclaimer. If you're going to list multiple people to be your agents at the same time, make sure they're able to come to an agreement and make decisions together. So that's where you can start. You can designate it and stop and say, I want this person to be able to make these decisions, and I want it to go into effect as soon as I sign it. But you can also say, I want it to go into effect at a specific date or based on certain circumstances. It's your choice. You can also write in like, hey, I'm designating person A as my healthcare agent. I want the doctors to be able to talk to them, and I want them to follow all of the doctor's recommendations and suggestions just as they are. If the doctor says this is going to work, I want you to take their advice and run with it. Do exactly as it said. Or you can say, I want the person to listen to the doctor, to take everything under advisement, but also I also want them to take into consideration the things that I've talked to them about my desires and my wishes, and make sure that the ultimate decision aligns with both of those. And then the other part of that, you can also specify that you want person A to be your healthcare agent, But in addition to consulting with the doctors, you also want them to talk to your family members or talk to people you specify of, hey, at least, talk to them to see how they're thinking. Ultimately, the decision is yours. But before you make any decisions, I want you to at least consult with these people, take all these different things into consideration. So like I said, with both of these documents, it can be as general. You can do it where it's very general, or you can get very detailed and specific. So if you are a details person and you're very particular about yourself, your healthcare, what you want, what you don't want, then I encourage you, this is an opportunity to still have a little bit of, have say so, or as much say so as you can, even when you are not in a position to speak up for yourself. So it can be, and then you can also go into specifying what you want that person to do or what you would want to have happen in various end stage conditions. You're not required to make those designations or selections in your, leave it alone, in your document, but you can. And so examples of this would be in the event that excuse me, I am diagnosed with a terminal illness, and there's no hope, no likelihood of recovery. Do I want the doctors to do any and everything they can to keep me alive, keep me comfortable, or no, just you keep me comfortable, but let me, pass naturally don't try to extend my life. The same in most times people hear, do they have a DNR, a do not resuscitate? You can specify in your advanced medical directive that if you were to code or flatline, do you want the doctors to keep trying to bring you back? Do any and everything you can to keep me alive, keep me breathing for as long as humanly possible? Or are you someone that says, no, just if I code, let me go? Or, try once or twice, but don't go beyond this time. If I end up in a position where I am in a vegetative state, or I'm brain dead, or I'm alive, but I have limited mobility, like you can get very detailed. But essentially the goal of it is to try to remove as much of the stress and uncertainty or guessing for your family and friends, as well as the healthcare providers in the event of these situations. So it's like you're given the opportunity to, as difficult and uncomfortable as it is, to sit down and think through, like, okay, if this happened, what do I want to happen? Like, what do I want them to do? How do I feel about this? And so that's why I say it's optional. You're not required to get that detailed, but you can. You can also specify that whether or not you want to be an organ donor, that in the event or when you pass, do you want to donate organs? Do you want your body to be donated to science for research? Do you I think I've seen too where you can say, I want my remains to be planted and become a tree, or, to do that. You can get very detailed in terms of what you would like to have happen with your body while you're alive, as well as once you pass away. But the key thing here is like I said, making sure you do it and you know that you have the right to do it. And it's great to write it down and, to write it down, to sign it, get it witnessed, make sure it's effective. But it's even more powerful if you first and foremost, let the person know, whoever you've listed as your healthcare agent, that they know that they're your agent, that they're not caught off guard, or they're, surprised when something happens and that's when they find out. You want to make sure they know that you are their healthcare agent. And then you also want to make sure you talk to them, or, at bare minimum, send them a copy of your advanced medical directive so they can read for themselves what you have decided, how you want it to be, and then have conversations with them about your desires, about what your thought process is or was in making those decisions. Because how I feel today, say hello. Hi. The way I feel today about what might, about a certain situation, I might feel a little differently when it comes. And so it's important to talk to your healthcare agent. So making sure it's someone who knows you, that you're comfortable with them and their decision-making ability, how they're able to make decisions under stress, because it's going to be a stressful situation. That's inevitable, especially if we're thinking it's an unexpected, even if it's one that kind of we've known about for a while, some type of illness. But when a person is sick or transitioning, there's some level of grief, there's sadness, it's an emotional time. And so we can't plan out and plan away all of those feelings or those emotions, but the goal is to minimize that stress, to
Oh, I love these.
you like those, to make life a little easier during that time. And so that's like I said, that's kind of the driving force of these documents. And so I don't want to keep going on tangents about it, but that's, like I said, the goal is just to let you know what they are, what's required, what it's covered, how detailed you can get, or if you want to just leave it as you're designating the healthcare agent and then you sign and get it witnessed, it's effective. And that gives, wait, let me finish. That accomplishes the goal of designating the person and then letting the medical providers know that they are authorized
I don't know.
to, they're authorized to talk to that person on your behalf. So those are, like I said, that is power of attorney and advanced medical directive.
I'm gonna put it back in.
Okay. And you can see my future healthcare agent. You can meet her now before she has that authority to do those decisions. But like I said, those are two components of a legacy plan. I consider those to be the life documents, and anyone who is 18 years or older needs or could benefit from having those documents. Take it back over there. Because the other thing to think about is, especially for those with children or even nieces, nephews, when children are going, whether they're going to college or they're 18 and they're still living with you. Once they're 18, they're adults. You are still their parent. But as far as, financial institutions, the law, or medical providers are concerned, they're adults and they are no longer required to those institutions or those medical providers are no longer required to give you information or talk to you on your child's behalf. So you want to make sure, especially in a college setting, the school, in most situations, they're prevented from disclosing that information from you unless that child or that person has given them permission or the authority to do so. So even for those, and I know school has already started, but we're still early on at something too as well. If you have children who recently went off to college or recently moved off, this is something to talk to them about as well, that they need to go ahead and create power of attorney and advanced medical directive to make sure that in the event that something happens, they've designated either you as their parent or some other responsible person to be the one that the school, the job, the medical providers, the financial institutions are able to speak to and release information to you or to whomever they've designated on their behalf in the event that something happens. So that's something else to think about. So this is not one of those things of I've got to be a certain age. I've got to have a certain number of assets. Like if you are alive, you need these documents. Um, Not right now. If you are alive, you need them. And so with any estate plan or legacy plan that I do, whether it's a trust-based plan or a will-based plan, the power of attorney and advanced medical directive are included in those packages because, like I said, that is a part of a comprehensive plan. So um, or if you're someone, hey, I already had a will or I had this, or you're someone who is younger and just like, I want to make sure I get those documents, that is something that we can provide as standalone documents as well. But if you reach out and say, hey, I need a power of attorney, I'm going to ask, well, do you have an advanced medical directive? Do you have a will? Do you have any things in place? If you just want this document right now, great, cool, I'll do that. But I'm at least going to have that ask those questions so we can have that conversation because I feel like I'm doing you as well as my community a disservice by not at least informing you of what a comprehensive plan is and what the benefits of those plans are. So thank you again for joining today. I do hope that this information was helpful. If you have questions, you can put them in the comments or you can reach out via email at info@lalegalsolutions.com. And that's Lalegael. Excuse me. I can't spell right now. So it's LA Legal Solutions with a Z at the end. So instead of an S at the end, it's a Z. So info@lalegalsolutions.com. And like I said, this will be here on Facebook for a while. If you missed the live, if you'd like to watch it again or share it with others or watch any of the previous conversations, they are available on the LA Legal Solutions YouTube channel. Today's sessions should be up within a week. If you have questions or you would like to hear me talk about specific topics, or there's other professionals that you would like to hear from or to talk about different aspects of legacy planning, please send me a message, put it in the comments and let me know. So that way, I want to make sure that this is effective and we're addressing any questions or concerns that you may have. Of course, if you would like to hire me, you can reach out the same information or the website lalegalsolutions.com to schedule a consultation to get started on your legacy plan today. For my entrepreneurs, we also provide a business formation as well as business advisory services. And we have a Legacy Builders membership program where it's a monthly subscription that gives you access to a consultation with me or one of the other attorneys every month, as well as access to contract templates that have been drafted by myself and my colleagues, and discount on any legal services that you purchase from us. So thank you again. I hope you enjoy the rest of your Saturday and the month, and I will see you next month.